Question number 9 asks what are the consequences of notice given to an agent, and those consequences of notice given to agent is provided under section 229 of the Indian Contract Act 1872, and in relation to that we'll discuss certain illustrations also. Such leading cases like Willie versus Poland 1863, the judgment was delivered by Lord Justice Chancellor, and then B.N. Bin Shankar versus Sri Vivekanand Cooperative Housing Society Limited, and others in 1986 by the Gujarat High Court. Then Baldwin versus London Assurance Company 1892, the judgment was delivered by Queen's Bench. And lastly Goldstone versus King in 1813. So the very consequences of notice as provided under section 229 regarding the very consequences of the notice given to an agent. Any notice given to or information obtained by the agent, provided it be given or obtained in the course of the business transacted by him for the principal, shall, as between the principal and the third parties, have the same legal consequences as if it had been given to or obtained by the principal, as it is provided under section 229 of the Indian Contract Act. And so, regarding that, the very illustration that we discuss, illustration number 1 is that A is employed by B to buy from C certain goods of which C is the apparent owner, and buys them accordingly. In the course of that treaty for the sale, A learns that the goods really belong to D, but B is ignorant of the fact. B is not entitled to set off a debt owing to him from C against the price of the goods. And the second illustration is that A is employed by B to buy from C goods of which C is the apparent owner. A was, before he was so employed, a servant of C, and then learned that the goods really belong to D. But B is ignorant of this fact. In spite of his knowledge of his agent, B may set off against the price of the goods as a debt owing to him from C. So, these very rules govern the very consequences of notice given to an agent. As we analyze these two illustrations in relation to the very provision under section 229, and now we'll discuss the first leading case, and that is Willie versus Poland, a leading case of 1863, and the very judgment was delivered by Lord Justice Chancellor, and as the rule laid down in section 229 is intended to declare a general principle of law, it is not a mere question of constructive notice or inference of fact, but a rule of law which imputes the knowledge of the agent to the principal, or in other words, the agency extends to receiving notice on behalf of his principal whatever is material to be stated in course of the proceeding as it was declared in the leading case by Lord Justice Chancellor in 1863, and the next leading case, that is Jain Beni Shankar versus Sri Vivekanand Cooperative Housing Society Limited and others in 1986, the Gujarat High Court expressed that under Section 229, notice given to or information received by the agent, provided it be given or obtained in course of business transacted by him for the principal, shall as between the principal and the third parties have the same legal consequences as if it had been given to or obtained by the principal. Thus, where notice of a partner's retirement from the firm was given to the secretary who was in de facto and de jure charge of the third party society, it was held that its plea that notice to its secretary was no notice to it was not tenable, as it was expressed by their lordship, the Honorable Gujarat High Court. So, from the very following decisions, the last one that we'll discuss, an English leading case, Goldstone versus King in 1813. So, an agent of an insurance company having negotiated with a man who had lost the sight of an eye, it was held that the agent's knowledge of the fact must be imputed to the company, and could not that it could not avoid the contract on the ground of non-disclosure thereof by the assured, as it was held by the very leading case, Badwan versus London Assurance Company 1892 by the Queen's Bench. And lastly, as we discuss in the last leading case, Goldstone versus King, a ship sustained damage in the course of voyage, and the master subsequently wrote a letter to the owner but did not mention the fact of the damage. It was held in this leading case that the master ought to have communicated the fact, and the owner, having insured the ship after receipt of the letter, that the insurance was void on the ground of non-disclosure. So, this is the very judgment delivered in the leading case, Goldstone versus King. So, there are certain principles which govern the very consequences of notice given to an agent as provided under Section 229 of the Act. And in our upcoming video, we'll discuss The last question, that is relating to question number